This is Barry Zalma on insurance. I'm an attorney who is retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to speak about some common tactics used by plaintiffs' counsel to set up a bad faith claim. One tactic for setting up a bad faith claim is to make a settlement offer that likely cannot be complied with by the insurer. Knowing the settlement demands may not be met, the insured claimant waits for the insurer's misstep in not accepting the demand and then asserts a bad faith claim and refuses to negotiate settlement further. Sometimes the insured/claimant will make an offer for settlement containing an arbitrary and unrealistic deadline for acceptance, before the insurer had the opportunity to fully investigate the claim. When the insurer is unwilling to agree immediately to the insured's or claimant's demands, a bad faith claim and suit is filed. For example, in DeLaune versus Liberty Mutual, a 1975 decision of the Florida Supreme Court, plaintiffs made an offer to settle their claim stemming from an automobile accident for the $10,000 policy limit, attaching a 10-day deadline for the defense to accept the offer. Defense counsel, believing the settlement for the policy limits was possible, but not yet authorized to approve the settlement, contacted the plaintiff's counsel on the last day of the deadline and asked for an extension of the offer until the following Monday after the Friday deadline. The plaintiffs refused and initiated a common law bad faith lawsuit for the excess judgment that eventually resulted. These developments have resulted in the bad faith landscape in some jurisdictions appearing geared more closely to providing policyholder counsel with a lucrative recovery than safeguarding the appropriate balance of interest between an insurer and its insured. With bad faith claims viewed as the gateway to recovering attorney's fees and damages well in excess of policy limits, insurers and policyholder counsel need to be well versed in addressing scenarios in which an insurer's allegedly flawed investigation, settlement practices, and/or noncompliance with statutory claims handling requirements open the door to extra-contractual disputes. When courts and juries see through the conduct as a setup, as an orchestrated plan by the claimant or his or her counsel, they are more hesitant to find the insurance company liable for bad faith. Unfortunately, more often than not, neither the court nor the jury sees through the conduct as a setup and allow prejudice against insurers to carry the day, and a punishment verdict is issued. As long as bad faith setup attempts succeed, they will continue to be used. The potential for punitive damages against an insurer who fails to pay policy limits after receiving a reasonable offer of settlement creates an unreasonable temptation to the policyholder lawyers to make policy limits demands quickly and within a very short time limit, hoping the insurer is either unwilling or unable to meet the time limit. It is inappropriate conduct and often acts against the interest of the client. Regardless, the ploy often works. Sometimes, like in Graziano versus Mercury General Corporation, a 2014 decision of the California Court of Appeal, the plot and ploy fails because the ploy was obvious and clearly unfair and prejudicial to the rights of the insurer. In that case, plaintiff Sonia Graciano suffered severe injuries when she was struck by a car driven by Saul Ayala. Saul was insured by a policy issued by California Automobile Insurance Company, which had policy limits of $50,000. Less than 3 weeks after Graciano's attorney first contacted CAIC alleging Graciano was injured by one of CIAC's insureds, during which time Graciano misidentified both the name of the driver and the applicable insurance policy, CIAC completed its investigation of the accident, identified the correct insurance policy and driver, and tried to settle Graciano's claim against Saul by delivering to Graciano's attorney a full policy limits offer. Graciano did not accept the full policy limits offer and asserted that CAIC and its parent and affiliated companies acted in bad faith based on an alleged wrongful failure to settle. Graciano argued that CAIC could have and should have earlier discovered the facts and should have made the full policy limits offer more quickly. The jury found in favor of Graciano and the insurer appealed. Saul reportedly fell asleep while driving and had struck the woman and injured her. Based on the preliminary information, CAIC believed the driver was 100% at fault. By October 30, 2007, the adjuster believed it would be likely an excess bodily injury claim, meaning the amount for which Saul was liable would exceed the amount of coverage provided by the policy. CAIC apparently did not know at that point the identity of the person injured by Saul. 3 days after Saul's report, lawyer DeLaune contacted CAIC's call center in Texas to report her client Graciano had been injured by a driver insured by the CAIC. DeLaune reported Graciano was injured on October 21, 2007, and gave the call center a policy number with CAIC and told the CAIC's driver was Sauleh Allah. On November 5, DeLaune mailed a demand letter to the insurer advising that Jose was the named insured, that the policy number AP 00401514. The date of loss was October 21, 2007, and described Graciano's extensive injuries. The offer to settle for verified policy limits was stated to expire within 10 days of the date of the letter. That letter was not received by the insurer's adjuster until November 8, or 2 days before the expiration of the offer. The previous day, the adjuster first received the police report, which correctly reflected Saul was the driver, but still listed Jose's old policy as the applicable insurance policy. By Monday, November 12, CAIC's investigation of Graciano's report and claim had determined Saul, whom the newly obtained police report listed as the driver who struck Graciano, was a non-listed driver on Jose's policy and, according to the police report, did not reside at Jose's address. That day, CIAC again tried without success to speak with lawyer DeLaune about Graciano's claim. CAIC immediately prepared a letter offering the $50,000 limit, which it identified as the limit on Saul's policy in full and final settlement of Graciano's injury claim. Graciano did not accept the offer to settle her claims against Saul. Instead, she pursued her action against Saul. Graciano obtained a judgment against Saul for over $2 million and obtained an alleged assignment of Saul's rights under the CAIC policy. The court excluded evidence proffered by the defense to support its argument that DeLaune's offer to settle for the policy limits was not a genuine offer, and that once CAIC informed her that it appeared there was no coverage under Jose's policy, its subsequent efforts to settle on behalf of Saul were hampered by DeLaune's machinations. Although lawyer DeLaune knew not later than November 7, 2007, that the driver's name was Saul Ayala Jr., her November 5 demand letter, as well as her November 7 letter enclosing Graciano's medical bills, and her November 8 letter reiterating the November 15 deadline for CAIC to respond, continued to refer solely to Jose and Jose's policy number without any mention of Saul. The law clearly states that erroneous denial of a claim does not alone support tort liability. Instead, tort liability requires that the insurer be found to have withheld benefits unreasonably. An insured's claim for bad faith, based on an alleged wrongful refusal to settle, first requires proof that the third party made a reasonable offer to settle the claims against the insured for an amount within the policy limits. A claim for bad faith based on an alleged wrongful refusal to settle also requires proof that the insurer unreasonably failed to accept an otherwise reasonable offer within the time specified by the third party for acceptance. Nothing in California law supports the proposition that bad faith liability for failure to settle may attach if an insurer fails to initiate settlement negotiations or offer its policy limits as soon as an insured's liability in excess of policy limits has become clear, but instead requires proof the third party made a reasonable offer to settle the claims against the insured for an amount within the policy limits. The court concluded that there was no evidence Graciano ever offered to settle her claims against Saul for an amount within Saul's policy limits. The only evidence in the record was that Graciano misidentified the applicable policy and did cause actual prejudice to CAIC because the insurer showed a substantial likelihood that, with timely notice, it would have attempted to settle the claim. Once CAIC learned of the applicable policy, it did not decline coverage for the same reason or for any reason, but instead proffered the full policy limits in an attempt to protect its insured. Because the undisputed evidence showed CAIC was actually prejudiced by the misidentification of the applicable policy, and also showed, notwithstanding the misidentification, CAIC undertook a continuing investigation, there was no evidence to support a judgment against it. When a liability insurer timely tenders its full policy limits in an attempt to effectuate reasonable settlement of its insured liability, the insurer has acted in good faith as a matter of law, because by offering the policy limits in exchange for a release, the insurer has done all within its power to effect a settlement. Counsel for the plaintiff attempted, by making quick policy limits demand with a short 10-day limit to respond, believed she had set up CAIC for a bad faith judgment and could collect the full $2 million verdict from the insurer with only a $50,000 limit. By demanding settlement from the wrong person with the wrong policy, the attempt failed. Counsel, to protect the client, should have dealt in good faith with the insurer and accepted the $50,000 when it was pointed out to counsel that the delay in offering policy limits was due to the failure to properly report the name of CAIC's insured and the policy number. There are other ways to set up bad faith claims, including demands where the policy provides no coverage, demands under policies with multiple coverages, demands with short time limit, making it impossible for the insurer to conduct a thorough investigation, demands made while refusing the insurer's right, the ability to interview the claimant, demands made for policy limits when the claim's injuries do not warrant settlement for policy limits, and demands made for policy limits when the injuries claimed were fabricated. This video is part and parcel of all of my books, including my books on the tort of bad faith and why it is time to reduce any claim for the tort of bad faith. These books are available from Amazon.com as both a Kindle book or a paperback, and are detailed and outlined in the insurance claims library, which is a link on my website, Zalma.com. If you found this video to be interesting or useful to you or your colleagues, please pass it on. It's free, and please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can learn about future videos and future blog postings. Thank you for your attention.